Debt collection, settlement and common strategies. In this video, you will learn how to try to settle your debt collection case and how to submit your evidence in the trial. We are going to start with settlement because a negotiated settlement is often the best result, especially if you can come to the settlement before you have to go to trial. Settling with your creditor usually means that you are going to agree to pay part of the debt in exchange for the creditor dismissing the lawsuit against you. Not only can you try to negotiate the total amount of the debt, but you can negotiate the payment terms. For example, perhaps you are able to make a one-time lump sum payment to the creditor. Or maybe you need a payment plan so you can pay a smaller amount every week every month. Negotiating a settlement with your creditor is not as hard as it seems. Most creditors would rather settle than go to court and risk losing the case. You can negotiate with your creditor at any time, but if the creditor has hired an attorney or a law firm to handle the claim against you, you must speak to that attorney or law firm instead of the creditor. Important point: if your creditor has filed a lawsuit against you, make sure to file an answer in the lawsuit by the deadline. Talking to your creditor or your creditor's attorney does not stop the clock. You still must file an answer, or you risk having a default judgment entered against you. Here are the steps to take if you want to try to settle the debt with the creditor. After you file a response answer, you may be able to negotiate a settlement before your trial date or even on your trial date in the courthouse before the hearing. Just about anything can be negotiated and decided through a settlement agreement. If you are experiencing severe financial hardship, you may be able to ask the creditor for a hardship dismissal of the debt, as it does not make sense for them to pursue what you truly cannot afford to pay back. The first step is to ask opposing counsel what they need for a hardship dismissal, whether it will be a form or a request for general information. The information they are asking for is evidence of your hardship. That would be proof of your income and expenses, which, if it shows that you really will not be able to pay this debt, may be enough for the creditor to grant you a hardship dismissal. Sometimes a signed declaration from you is enough. Sometimes proof of receiving Supplemental Security Income (SSI) or Social Security Disability Insurance (SSDI) is enough. Sometimes they want all household income and proof. Ask them directly for what information they specifically require and do not give more information than necessary to your creditor. If the creditor asks you for bank statements, be sure to block the account numbers and any reference to your social security number. The same goes for medical bills or any documents showing that information, such as your pay stubs. You don't want to give the creditor a roadmap to all your information, which they can then use to try to garnish you if settlement talks fall through. You may want to prepare a hardship declaration, a document that shows proof of your income and expenses, so the creditor's attorney can see that you cannot afford to make any payments and are unlikely to be able to do so in the future. The goal is to show that you are judgment-proof or collection-proof, which means that you do not have anything that a creditor can take in satisfaction of the debt. Many creditors will not continue to try to collect when a debtor shows he or she is judgment-proof or collection-proof. To see if a debtor is judgment or collection-proof, a creditor assesses the amount of money in your bank accounts, how much money you make at your job, whether you own a home or a car, and if you do, whether there is any equity in the home or car. The creditor will also consider the available exemptions. An exemption is a dollar amount that the creditor cannot take, no matter what. For example, in most cases, but not all, pension payments and government benefits are exempt as long as they are direct deposited into your account. That means that the creditor cannot take it. As another example, in most cases, but not all, the creditor must leave a minimum amount in your accounts and cannot leave you with $0. Check Form EJ 156 for current dollar amounts exempted from levy. During settlement negotiations, remember that opposing counsel is not your friend. Make sure you know all the terms of the settlement agreement and that the proposed payment plan is within your budget. To settle your case: 1. First, organize all your papers, documents from the court, documents from plaintiff creditor, and documents in your possession. 2. Figure out what you can afford to pay. 3. Make a list of your monthly income and expenses. 4. And lastly, calculate any income that may remain. Use this to determine the amount you may be able to pay as a lump sum settlement or in monthly payments. Make sure you can really afford this amount because many settlement agreements include a clause that terminates the settlement agreement if you miss a payment. You can propose a lump sum settlement, or you can propose payments over time, or a combination of the two. If you need to make periodic payments, for example, monthly or weekly, you will probably have to settle at a higher total amount than if you make a lump sum settlement. Once you have figured out what you can afford to pay, decide on your opening offer. The opening offer should be approximately 50% less than where you want to end up. If you can afford to pay $100 per month for the next 24 months, your opening offer would be $50 per month for the next 24 months. This leaves you room to negotiate. Now that you have your numbers ready, reach out to the opposing counsel. Telephone is best. Start the conversation by asking what it would take to resolve the case in a lump sum or in payments. This will give you an idea of how far apart you and the opposing counsel are. Usually, the lawyer on the other side will say that he or she must discuss the matter with his or her client, and you won't get a firm answer during that first phone call. This is okay. Don't let it discourage you. Ask the lawyer if you follow up via email to document the negotiations and try to send a follow-up email in a few days. Resume negotiations, and if the creditor rejects your initial attempts to settle, do not be afraid to try again. It may take one or several tries to settle. If you succeed, now you must get the settlement in writing. Make sure you address the following standard terms in your settlement agreement. 1. What happens to the court case after you and the creditor enter into a settlement agreement? In particular, whether the case will be dismissed and whether the dismissal will be with prejudice or without prejudice, and 2. How much will you pay and when? If your case is dismissed with prejudice, that means that the creditor can never bring this case against you again. If your case is dismissed without prejudice, that means that the creditor can bring this case against you again. For a settlement with periodic payments, make sure you ask how you are supposed to make payment: by mailing a check, using a designated website, paying by phone? Be sure to ask whether you can pay off the debt early, and if so, are there any consequences or any benefits? You don't want to pay a penalty if you pay off the debt early. Be sure to find out what happens if your payment is late. For example, is there a grace period? A grace period is usually a few days after the due date, during which time the creditor will not mark you in default. Grace periods are not always included, but you can always ask for a grace period while you are negotiating. It is best not to agree to a stipulated entry of judgment because the whole reason you are trying to settle the case is to avoid a judgment. Instead, propose that a notice of settlement be filed with the court and that the plaintiff dismisses the case within 30 days after you make your final payment. Get the agreement in writing. Email confirmation of the terms is better than simply a verbal agreement, but a separate settlement agreement in writing and signed by you and by the creditor or the creditor's attorney is best by far. Make sure the settlement agreement includes details of the lawsuit. 1. Case number. 2. Court where the lawsuit was filed. 3. Exact names of creditor, plaintiff, and you, defendant. 4. And properly reflects what you have agreed to. Request a line in the settlement agreement that states that this is a settlement of a disputed debt. This will help if the creditor sends a 1099-C cancellation of debt form to you and wants you to include the debt forgiveness in your income for tax purposes. If you have the disputed debt language, your tax advisor may be able to dispute the issuance of the 1099-C form. Be sure to mark the due dates on your calendar and be sure to send the payments early enough that they will not be late. Most settlement agreements also include an explanation of what will happen if your payments are late or missed. Usually, a missed or late payment will kill the settlement agreement, and the amount due will jump back up to the original amount that the creditor asked for in the lawsuit, and the creditor may enter a judgment. Make sure to consult a tax advisor because the partially or entirely forgiven loan may be treated as income 1099 form, and you may have a federal tax liability. When a creditor forgives your debt or settles it for less than the original amount, the creditor will usually report the event to the credit reporting agencies as a negative event. This will likely lower your credit score, at least temporarily. To prevent this, during the settlement negotiations you can also ask the creditor to remove the trade lines. Trade lines are information that creditors place on your credit report through a credit reporting agency. If the creditor has dismissed your case with prejudice, they will likely agree to remove the trade lines. What happens if you cannot settle and you have to go to trial? Review the next video in this series for information on how to prepare for trial. Community Legal Aid SoCal envisions a world where equity and justice are not a goal but a given.